Good afternoon. My name is Thomas Martin, and this presentation is titled Religion in Schools. The purpose of this presentation, other than for educational purposes, is to ensure Dodge City Public Schools alignment with United States Department of Education and court rulings regarding religion in public schools. Mr. Donald Trump has spoken on this issue. He has defended prayer in public schools. He's also urged administrators to remember that students have religious rights and they're also able to express their religious beliefs with certain boundaries in place. He stated that teachers can participate in prayer, but they cannot lead prayer or read devotionals to students. He also stated that currently students' religious expression is being subdued in public schools, and he's taking action taking steps to address that currently. Now I'm going to discuss some court rulings that have been determined for the use of prayer. Croft versus Perry in 2009 stated that a moment of silence is allowed if it is secular in nature. So if a student decides to pray during that moment of silence, the school is not responsible for that student-led prayer. Lee versus Wiseman in 1992 ruled that a clergyman was not allowed to deliver prayer at a commencement. Because that prayer was not being delivered by a student, it was not allowed. So in 2019, the Supreme Court was asked to review a case of a football coach that had been fired for consistently praying with leading prayer with his players. The Supreme Court declined to review that because consistently it has been determined that students are not, or that staff are not able to lead prayer for students. So there have also been consistent rulings against adults working with students for student-led prayer. Because if adults are working with students for the student-led prayer, then it's no longer a student-led prayer. Adler versus Doral County School Board ruled in 1996 that a student can deliver a religious message in commencement if that particular student was not chosen for the delivery of the religious message. That if it was his or her decision to deliver the religious message, then that's okay. Bannon versus School District of Palm Beach County in 2004 ruled that it required the removal of religious content from a school project because the project was not developed for the intention of and for the purpose of allowing students to express their beliefs, because they did choose to express their beliefs, their religious beliefs. Those particular components needed to be removed from the display. Court rulings regarding religious instruction. So this states that the Bible may be taught as literature, but is unconstitutional to have Bible study in school because now that is no longer teaching the Bible as literature, but it is teaching the Bible as truth. Epperson versus Arkansas in 1968, this banned the removal of evolution theory from biology course. So Arkansas had attempted to remove the evolution theory from biology course, and this ruling banned that removal. Next, again in Arkansas, Edwards versus Arkansas. So Arkansas had attempted to ensure that creationism was being taught equally to that of evolution theory. Again, this was banned because creationism has a religious nature, or is religious in its origin. Kitzmiller versus Dover Area School District in 2005, this banned the instruction of intelligent design theory as replacing evolution, because again, intelligent design theory has a religious basis. Suarez versus Klein in 2006 ruling stated that symbols can be displayed if they also, so religious symbols can be displayed if they also have a secular meaning, or if they're being utilized for educational purposes. So a cross, if we're speaking about religion or teaching about Christianity, then a cross is able to be temporarily displayed. Court rulings regarding religious protections. So Harper versus Poway Unified School District 2006 required a student to, so this ruling required a student to remove a shirt that displayed discrimination against homosexuality with a religious basis. So the student's shirt had religious scripture messages that were basically stating that homosexuality was a sin. Well, because that was discrimination against students that consider themselves homosexual, then that student's shirt had to be removed. Brown versus Hot, Sexy, and Safer Productions. So this was a sexual education seminar that was being offered or being required for students to participate in, and several of the parents discussed that or tried to get their students to not have to attend that seminar. Because it did not coincide with their religious upbringing, but the determination is that exposure to this material would not hinder their religious upbringing. So Parents for Privacy versus Dallas School District Number 2. This was a court case that parents felt that their students' religious rights were being violated because students' transgender rights were being honored, and the court determined that providing or honoring the transgender student, the student that identifies himself as transgender, honoring his or her rights did not hinder the religious rights of others. Court rulings regarding religious activities. So Wig versus Sioux Falls School District in 2004 determined that teachers are free to participate in religious organizations outside of school hours, even in buildings where they teach. So even if a church group met at a school where this teacher taught, that teacher would be allowed to participate in that religious organization. Rosenberger versus University of Virginia and Good News Club versus Milford Central School District. This stated that access to resources should be equal for religious and secular groups. So it basically doesn't matter whether the group is religious in nature or secular in nature. They all need to have equal access to resources. Maryland versus Montgomery County Public Schools in 2006 determined that the religious group content must have equal access to promote the group as secular groups. So depending on whatever platform is used for recruitment or advertising of secular school groups, then that same access needs to be afforded to religious groups. Religious expression in public schools. This was revised in 2003. These are just some principles that were delivered by the U.S. Department of Education, stating that students may participate in religious activity similar to students being able to participate in secular activity. Students may participate in religious assembly or prayer on school grounds, similar to secular groups' access to school grounds. So if a school group has a meeting before school that is secular in nature, then that same ability or access to the school needs to be provided for groups that are religious in nature. Students may not harass others on the basis of religion. So you cannot harass others in schools just because their religion differs from yours. Schools can also not make decisions favoring one religion over the other. Elementary and Secondary Education Act of 1965 had 3 different clauses just ensuring that all schools had policies, or that no schools had policies denying students the ability to participate in prayer. So the school also then must notify the government in writing, according to Section 8524, Part B. They must notify the government in writing that no policy exists which would deny students the ability to pray. Part C allows the government to withhold fundings if Part B is not received by the government. Application of court rulings. So this is just how some of those rulings are applied to the school setting. Prayer and readings of religious material may occur during non-instruction. So during those non-instruction times, students and staff are able to pray. Religious groups have same building access as secular groups. School staff may participate in religious activities during non-instruction time. A moment of silence. So this may include prayer, but it may also not include prayer, but it cannot be promoted either way. Prayer cannot be promoted. Students may be excused from school for religious activity. So if there is an activity that your religion requires your attendance, then the school is able to excuse you for that activity. Student work may include religious content, but the grade must reflect the student's alignment with academic standards. So they need to be graded based on the academic standards rather than that of the religious content. Student speakers can include prayer as long as that speaker is not selected for this purpose. Students can deliver religious content. Teachers cannot deliver religious content for any other purpose than to teach about religion. And students' clothing can display religion, but as previously stated, it cannot be discrimination. Equal Access Right Act. This just states that religious groups must have equal access to buildings. Religious group meetings can include a prayer. Religious groups can advertise and recruit similarly via media, which was previously discussed. Religious groups can meet during lunch and recess if other groups are permitted to meet during those times. And religious groups can require the leadership of those groups to share ideals of the group if necessary. Here are Dodge City Public Schools board policies. Religion cannot be promoted or discouraged. Students and staff may opt out of activities conflicting with religious beliefs, and there is actually a form that they can fill out to request that ability to opt out. And then it'll be determined if there needs to be a replacement activity or not. Religion can be taught in an objective manner, but not in a promotional manner. Religious symbols may be displayed temporarily for educational purposes, as I had previously discussed, and religious holidays can be acknowledged if they have a secular title and meaning as well. So Christmas break is known as a winter break for Dodge City Public Schools. And here are my references, and thank you very much.